All right, Mr. Backlund, are you able to hear me okay?
I can hear you.
Yes.
Yeah.
Great. Mr. Vernon?
Yes, I can hear you.
Okay, so we'll go on the record in Collin versus Collin. This is file number 2411622. If I could just have both counsel put your appearances on, starting with plaintiff.
Adam Vernon, on behalf of Susan Collins, present, appearing remotely from my office.
Zach Backlund on behalf of the defendant, Craig Collin, who's also appearing by Zoom, Your Honor.
All right, thank you. I have this set as a status conference in this case today. Mr. Vernon, from plaintiff side first, can you tell me where things are at and what we need to do going forward here to get final judgment entered?
So we just recently completed mediation for the second time. We were more productive at that mediation. We did reach several agreements. Mr. Backlund drafted an order affecting that and reducing all that to writing. We are in the process of reviewing it. It does not resolve everything. There are two issues still outstanding, and that essentially is the value of the house and the value of the business. But Mr. Backlund and I have been having communications on those issues. And I know Mr. Collin is working on getting a loan or additional financing to address a financial or a monetary payment to Mrs. Collin for her interest in those assets. So I think we're much closer than we were the last time we met with you. My suggestion would be that we schedule this for trial, and then Mr. Backlund and I continue working on getting the numbers, and hopefully we can reach an agreement before the trial date.
All right, Mr. Backlund?
Yeah, that's all correct, Your Honor. Essentially, it's simply the equity equalization and Mr. Collin being able to obtain financing that could potentially reach the ceiling of where we were at on that equity equalization. So to add on to that, I do believe then that the parenting time custody issues are resolved pursuant to our mediation agreement as well.
Yes.
And some of those were included in the proposed stipulated order that I provided to Mr. Vernon. I did just give that to him yesterday. So it may take a couple days for us to get through that. But I think if the court were to schedule a trial, my hope is that we would be able to resolve it before then. But if not, we at least have a potential end date for these parties.
All right, so first of all, in terms of the duration of the hearing, would half a day be enough, Mr. Vernon, given the issues that remain?
Yeah, there's only the two issues. So yeah, I think we could resolve those fairly quickly. So I'll have to.
Mr. Backlund?
I agree. Yeah.
Okay, so if the court sets this 60 days out for a half a day hearing, that builds in a little more time for some further negotiations. Mr. Vernon, any objection to that time frame?
I have no objection to that. I would leave that to Mr. Backlund and Mr. Collins. I don't know how long it's going to take for him to address the financing issue and get those the paperwork with the bank dealt with. So sometimes they can be quickly. I leave the timing to them.
Mr. Backlund?
That's a good point, Your Honor. And so I almost wonder if the court were to schedule the trial and maybe a final pre-trial a couple weeks ahead of time, or if you would simply like us to contact the court if we're still waiting on that potential financing, because that's certainly going to dictate the ability of us to be able to reach a resolution or potentially pivot to something else. And so I understand the court's time is very valuable, and I wouldn't want us to have to delay that if the financing became an issue. But at the same time, I understand, that's still 2 months worth of time for us to resolve that.
Yeah, so I think given that it would only be a half a day hearing, which would not be difficult for the court to reschedule if we need more time, and wouldn't be difficult for me to be able to fill if this hearing needed to be delayed. I think what I'll do is I'll go ahead and set this for a half a day hearing at about 60 days out. If the parties need more time, then I would just ask for a stipulation in order extending that time, and we can reschedule it. Obviously, the sooner you know that date isn't going to work, the better, so that I can use that time for something else. And by the same token, if the parties reach an agreement and everything's in place and you want to get before the court sooner than 60 days to take proofs, then just notify my office. I'm sure we can get you a date for that sooner. But that gives us a framework for going forward. I think it gives a reasonable amount of time where we all won't be coming back for nothing, and but also a reasonable period where it could be resolved within that time. So that's how we'll go forward. Mr. Vernon, on behalf of plaintiff, anything else I can address for your side?
No, Your Honor.
Mr. Backlund?
Nothing further. Thank you.
Okay, I'll put that into an order. I'll get that out to the parties along with the notice of date and time for that half-day hearing, and all parties are free to disconnect. Thank you.
Thank you.
Thank you, Judge.
Okay, we've got the parties connected on JP Morgan Chase versus Reed. This is file number 2511872. If I could have both counsel put your appearances on, starting with plaintiff.
Yes, Your Honor. Chris Royce, P49102 on behalf of plaintiff.
Juanita Massey appearing on behalf of Annalee Reed, the defendant who's seated to my right.
All right, thank you. The last time we had a hearing in this case was back in July. Parties were going to work towards a potential resolution. Mr. Reed on behalf of Mr. Royce on behalf of plaintiff. Can you tell me where things are at from your perspective?
Yes, Your Honor. We have not resolved the matter, unfortunately. I'm still hopeful and optimistic that we will be able to do so. However, at this point, I would just request a motion for summary judgment date that we would have or I have a target to work towards getting this case settled before I have to file it.
Okay, Ms. Massey, anything to add to that?
No, I think what he stated is correct. There's no settlement yet, and hopefully we can work towards a settlement.
Okay, so Mr. Royce, I can't give you dates from the bench here. My assistant does all the scheduling. So what I'll just do is, for purposes of our status conference order, I'll just set a deadline for filing of a motion for summary disposition within the next 60 days. And if you can contact my office, talk to Jennifer, she'll be able to get you a date for that, and then you can get your motion filed and notice for hearing and on the docket. And then, assuming that we're going to have a motion hearing, but as a backup control date, I'll set this for a status conference at about 60 days. If for some reason there hasn't been any motions filed, then that gives us a next date to meet to see where things are at or what had changed. But that gives us a framework for going forward here. Mr. Royce, any other dates I could address for your side here today?
No, thank you, Your Honor.
Ms. Massey?
No, Your Honor, thank you.
Okay. All right, I will put that into an order, and then the parties will also get the notice of date and time for that status conference in 60 days. Again, if for some reason we don't have a hearing on a motion prior to that. And that's all. Both sides are free to disconnect. Thank you.
Thank you. You guys have a great weekend.
You too.
Thank you.
that the name?
Yep.
Cool.
Mr. Thompson, are you able to hear me okay?
Yes.
Okay, and let's see. Oh, Miss Crispell's still joining in, so just a minute. All right, there we go. Okay, so we have everybody oops, we did have everybody connected.
I'm trying to get my video on.
Oh, there we go. Okay. All right, so we'll go on the record in Crook versus Crook. This is file number 2411820. The record should reflect that both counsel and parties are all present by Zoom video today. I have this set as a motion here regarding the mediation agreement and also a status conference. I had a chance to look at the motion and the response. Mr. Thompson, anything you want to add to what your motion is? Has anything changed since the filing of the motion?
Nothing's changed since the filing of the motion. I do have my client available if the court would permit testimony about whether she complied with the mediation agreement. I believe that's the factual issue that the plaintiff is raising in terms of why the matters should not be enforced.
I mean, I guess my question is, I understand that there's an issue with regard to property that Mr. Crook believes that there was some property he was supposed to get as part of the agreement that he hasn't gotten. But to me, that sounds like something that he would be more filing the motion for. So, I mean, what's going on, Mr. Thompson, that your client is asking to have done that's not being done?
Well, she's asking that the matter be settled and the parties, their mediation agreement be honored. I mean, the mediation agreement calls for her to receive real estate and other items, and that is all on hold now. So she's asking the court to essentially allow this consent judgment to be entered so she can, she has a check here today to pay off Mr. Crook as proposed in the mediation agreement. That is her request.
Oh, so you're saying Mr. Crook is refusing to go forward with entering the judgment?
Yes.
Okay, all right, I got it. Ms. Crispell, obviously I saw your response. So, I mean, is that the holdup here, that Mr. Crook doesn't want to go forward until he gets those items of property?
The the issue that he has with it is that, first of all, there was a representation that it's clothing and a Lone Ranger lunchbox, but it also includes a substantial record collection that he was to receive. And he, at this point, as his, without getting into privileged communications between him and I, and the privileged communications between and during mediation, the mediation agreement, or even what a proposed judgment indicates he's to receive those items of personal property, and since he didn't, he is to enforce that mediation would mean that his compromise on his claims, it was based on something other than this personal property, and it isn't indicated in the mediation agreement that that was what was indicated. There was nothing in the mediation agreement that said, oh, he's compromising all of his claims that he may have. Is, because he's getting these, it says he is to receive it. It also doesn't say anything about if it's not there. And if in fact it's not there, that was obviously not disclosed in the mediation agreement.
All right, so, I mean, just trying to figure out what to do here, because if the only evidence we're gonna have, is testimony from Mr. Thompson's client saying that, she's turned over whatever items were there, and to the extent that she hasn't turned it over, they're just not there, or they're gone. And Mr. Crook testifying that, that they should have been there and he should have them. I mean, is that what we're gonna have, is two competing, just people saying one thing and the other person saying the other? Because that's gonna be awfully difficult for the court to make a determination if that's all the evidence that we have.
We're asking that the entire thing be set aside because my client doesn't think it is fair for there to be a representation that he was going to receive these items and then he doesn't get them. And I know that the alleged claim is that it was lost somewhere by him, destroyed by him, that she has no explanation as to where it's at. Yeah, perhaps it does come down to a question of he said, she said, but that's not necessarily the only issue in this case. There was the reliance by my client to compromise claims that he has regarding other property, which I think then comes back into the court's purview to consider, not just this he said, she said issue. And yes, that would be something that would have to be brought before the court as far as the personal property is concerned.
All right, so Mr. Thompson, I mean, what's your response to the claim that essentially your client bargained away property that she wasn't in a position to return to Mr. Crook? Well, it sounds like what Ms. Crispell is arguing is that her client gave up certain things because he thought he was going to receive that property, and now he's being told that your client never had that property in the first place, or it was gone. So she was bargaining away things that she never even had, I guess is the argument.
Yeah, I think like every long-term marriage, there's a lot of things that are in storage, and the court has certainly presided over plenty of divorces. People ask for things, that doesn't mean my client made an independent, search of everything in storage. She's asking to enforce the mediation agreement, Your Honor. That's where we're at.
All right, well, I mean, I think number one, I'm gonna have to set this for an evidentiary hearing, because I'm certainly gonna have to take some kind of testimony and evidence beyond what I could do at a 15-minute hearing, and certainly within the next 4 minutes before my next two cases at 2 o'clock. So, and I guess part of that testimony would have to be who knew what about this property at the time of the mediation. And the court may have to make some findings in that regard, which may affect the viability of that mediation agreement. In other words, if the court finds that this property that should have still been, I don't know, I don't want to say too much, because a lot of it's going to depend on what the evidence is going to show here, but I think I understand what he says arguments are. I think this is something we could probably do in a half a day. Mr. Thompson, would you agree on that?
Yes.
Ms. Crispell?
Yes.
All right, and can I get this set for hearing within the next 30 days that I can find time? Is that too soon, or Mr. Thompson, would you be ready to go as soon as I can get you a date?
No, we're ready to go. I mean, in terms of the court's inquiry, I don't have any, subpoenas or discovery outstanding. I'm not aware of anything that's going to be in evidence besides the testimony. So we'd be ready to go as soon as the court is.
Okay, Ms. Christel?
There potentially might be one subpoena, Your Honor. So perhaps if we could set it on just past the 30 days, that should be sufficient.
Okay.
So between 30 and 60 days, I think would be adequate.
Okay. All right, so I'll get this set for hearing. I will send that out to the parties. With that issue outstanding, I don't think there's any point in doing a status conference at this point. I think that kind of delineates what the status of the case is at this point. So I will just set this for the half-a-day hearing. That'll be in person here in the courtroom in Grayling, and we'll go forward at that time. I don't think I need either of you to submit any briefs prior to that. I think I've got a handle on what the issue is here based on the motion and the response. So counsel, just be ready to go with your witnesses and we'll go forward from there. Mr. Thompson, anything else I can address for your side today?
Your Honor, I would just ask court and perhaps opposing counsel about whether the court would prefer to do this in person or via Zoom. And part of why I raised that is I know Mr. Crook has, some hearing difficulties. So I'd kind of ask opposing counsel what her preference would be in that regard.
Well, I indicated, maybe you didn't hear, but I did indicate it would be in person here in Grayling in the court.
I apologize. Thank you, Your Honor. That's what I was asking.
Yeah, I think for number one, it's an evidentiary hearing, so it's presumed to be in person. And I think if either side does have problems like hearing and so forth, I think we're better off doing this in person here in the courtroom.
Understood, Your Honor. Thank you.
Okay. All right, Ms. Christel, anything else from your side today?
No.
Okay. Thank you. That's all for this hearing, and both sides are free to disconnect at this time.
Thank you, Your Honor.
Oh, no.
What's next to you, and then maybe I can figure out.
On the main case, there's light,
Okay, that's one of them.
level, and height for.
Just near us.
Oh, you're doing Brigham.
Ms. Screen, what case are you signing in on? The person, counsel who signed in under Lisa Screen, can you tell me what case you're signing in under?
Yes, Judge, it's 25-11914-NI, Michael Pelia.
Oh,
P-A-I-L-L-E for plaintiff.
Got it. Okay, I've got one matter in front of yours, so I'm just going to put you back in the waiting room for a second.
Thank you, Your Honor.
Thank you. Okay, we'll go on the record in Brigham versus Brigham. This is file number 2511935. Ms. Neros, you're here on behalf of Ms. Brigham, is that correct?
Yes, Your Honor.
And I have this set for entry of a consent judgment of divorce today. Were you anticipating that Mr. Brigham was going to be present?
No, I was not.
Okay. All right. I will note for the record that both the consent judgment and the uniform support order purport to have Mr. Brigham's signature. And this was set for 2 o'clock. It's now 2:05 by my clock. It's set for 2:05. 2 o'clock. It's now 2:05 by my clock. Boy, Friday afternoon, I'm having trouble talking here. Mr. Brigham has not appeared. So given that his signatures are on the relevant documents and he's not present, we can go forward. Ms. Neros, are you prepared to take proofs from your client today?
Yes, I am, Your Honor.
Ms. Brigham, if you could raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Ms. Neros, please proceed whenever you're ready.
Thank you. Mara, can you please state your full name for the record, spelling your last?
Mara Lynn Brigham, Brigham.
And did you previously marry the defendant on February 8th, 2023?
Yes,
And this is your second marriage to the defendant, is that correct?
yes,
And do you recall filing a complaint for divorce on or about June 30th, 2025?
yes,
And in that complaint, or I'm sorry, let me back it up. At the time of filing that complaint, had you been a resident of the county of Crawford for at least 10 days?
yes,
And of the state of Michigan for at least 180 days?
yes,
In the complaint, you've alleged that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that this marriage can be preserved. Was that statement true at the time of filing?
yes,
Is that statement still true today?
yes,
So there's no way that you could reconcile or otherwise preserve your marriage, is that correct?
that's correct.
And do you have any minor children from your marriage with the defendant?
No,
Are you currently pregnant by chance?
no,
And have you reached an out-of-court agreement pertaining to all property-related issues in this case?
yes,
And is that agreement accurately reflected in the proposed consent judgment of divorce that we've signed, I believe, on August 13th, and submitted to the court?
Yeah.
And do you believe that the property settlement terms contained in that proposed consent judgment are fair and equitable under the circumstances?
yes,
And as part of that award, you are being awarded spousal support, is that correct?
correct,
And you've had a chance to review the uniform spousal support order and the attachment to that spousal support order.
correct,
And you understand that that's final and binding and it's non-modifiable.
correct,
And you're aware that the defendant is receiving no spousal support and his claim for spousal support will forever be barred by this court.
yes,
And you are aware that the property settlement terms are final and binding absent some exigent circumstance like fraud, duress, and you cannot come to this court and modify those terms.
yes,
And you understand that by entering into a binding settlement agreement on all property issues, you've elected to forego your right to proceed to trial in this case.
yes,
And you've also foregone your right to engage in any discovery in this case.
Yeah.
And you have signed this proposed consent judgment of divorce as an act of your own free will.
yes,
And are you asking this court to enter the judgment of divorce, grant you a divorce from the defendant?
yes,
I have no further questions, Your Honor.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the plaintiff. I've reviewed the proposed judgment as well as the spousal support order. Court finds that they comply with statute and court rule and are generally equitable. I signed both with today's date, and the court will grant the divorce. Ms. Neros, anything else that we need to address for the record on behalf of your client today?
No, nothing further, Your Honor. Thank you.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
yes.
Yeah.
Okay.
Okay, we have both counsel connected, so we'll go on the record in Haley versus Lane. This is file number 2511914. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Lisa Screen appearing on behalf of plaintiff, and I do believe there's two defense attorneys on this one, if I'm not mistaken.
And Your Honor, I'm filling in for Kaylin Piper. This is Robert Jordan. I am defending on behalf of Pioneer State Mutual, but that's all I have.
Okay. I don't think I have an appearance by any other defense counsel at this time. So
Oh,
let me double check on that, though. The clerk's gonna double check that.
So I have Charles Lavelle. He is appearing on behalf of US Specialty Insurance Company. And he should have received notice for today.
Your Honor, would you like me to call his office?
Yeah, if you don't mind, that would be great. It looks like the notice of this hearing was sent out on August 20th, and he was listed on the proof of service. So yeah, if you wouldn't mind, that would be great.
Absolutely, Your Honor.
So Mr. Lounsbury was served, no answer, no appearance, no default. Defendant Lane has not been served. That's when it just got the second sentence reissued.
So that's served, yeah.
The first defendant hasn't been served. The other one has been served. No default, no answer, no appearance on behalf of him. Who, when the appearance came, because sometimes like the notice goes out and they file that. So.
Your Honor, thank you for giving me the opportunity to call. The secretary indicated it was not on his calendar. I gave her the Zoom information. She's going to have someone log on.
Okay. Thank you for doing that.
Absolutely.
Okay, council, we're gonna move forward because I do have to go on with my docket. Oh, here we go. They just popped in. All right. Okay, council, you're signing in for Mr. Lovell, is that correct?
I am. I'm so sorry for the tardiness, Your Honor.
That's all right. Can you put your appearance on for me, please?
Yep. Good afternoon, Anna Katz on behalf of U.S. Specialty.
Okay, we're on the record today for purposes of a scheduling conference in this matter. I think this is everybody's first appearance before the court. So just want to get an idea of where things are at. It sounds like this screen that there is still yet one defendant that's kind of out there that you're trying to get service of. Is that correct?
I believe so, Your Honor. But this is a third party. The parties that are currently in the case, we've exchanged initial disclosures and discovery as well. So I think we are moving on track. I'm not sure if the other two will be defaulted or not.
Okay. How do you want to go forward in terms of scheduling? Do you want to just get this, just do like what I would typically do, a standard scheduling order? Or is this a case where you all want to try some early mediation or some early negotiations, something like that? Or Ms. Screen, what's your thought on that?
My preference would just get a regular scheduling order and not do any type of pre at this juncture.
Okay.
Go ahead and open up discovery would be my preference.
Okay.
I'd agree with that too, Your Honor.
All right, Ms. Katz, any objection to that?
Yep, I agree with that as well.
Okay, so, and Ms. Screen, I might have missed it, but in terms of discovery, did you just state a period for discovery there?
I did not, Your Honor.
Okay. Do you have any preference on that? How long?
No, Your Honor.
Mr. Jordan or Ms. Katz?
We would request 180 days, Your Honor.
All right, Ms. Katz, any objection to that?
No objection.
No objection.
Okay. So we'll set discovery for a period of 180 days. I typically order mediation within that 180-day period. And in the pretrial order that you'll get, there's a specification that counsels to confer and attempt to reach an agreement on a mediator and notify the court in writing of the selection. And then the order will specify that mediation is to occur within the period set aside for discovery. Ms. Screen, any objection to a dispositive motion cut off 30 days following the close of discovery?
No objection, Your Honor.
Mr. Jordan or Ms. Katz, any objection to that?
No, Your Honor, but from Pioneer's perspective, no objection. But just for clarification, is that a filed and heard or just a filed date?
Filed.
Okay, thank you.
No objection.
Okay. All right. Defense counsel, did you want to reserve an IME? Is that something that would be at issue?
Yes, Your Honor, we would like to reserve an IME.
Us as well.
All right. Aside from that one defendant that's still outstanding, Ms. Screen, are there any other defendants or parties that you anticipate you're going to need to add or pleadings to be amended?
No, Your Honor.
Mr. Jordan or Ms. Katz?
Not at this time, Your Honor, no.
Not that we're aware of.
Okay. All right. And so usually what I do is I set those dates that we've already discussed. I set for a status conference about the time of the close of discovery. If the case is mediated, obviously we can take that down. If the case is still going at that point, then we can address, where the parties are at and how to schedule further from there, depending on whether it looks like it's going to be proceeding to trial or whether more ADR is contemplated or motion practice and so forth. And those are typically the only dates that I set at the beginning. Ms. screen, are there any other dates that you would like to request that the court set as part of the pretrial order?
Not at this time, Your Honor.
Mr. Jordan,
At this time, Your Honor.
Ms. Katz.
Not at this time, Your Honor.
Okay, so I will put those dates into an order that'll go out to all of you, along with the date and time of that status conference at about 180 days. And you're all free to disconnect. Thank you.
Thank you, Your Honor.
Thank
Have a
you,
great
Your Honor.
day.
Have a
Thank
great
you.
weekend, everybody.
You too.
Too.
All right, that concludes